need a law for everything, so we wouldn't recommend it, but we wanted to bring it up for discussion, and if it comes up, you can say you thought about it and talked about it.
So the language as it stands here, it's, like you say, it's encouraging, right?
Yeah.
It's not enforcing, it's not remedial. Okay, so it changes nothing.
Correct. My only issue with having what I view as kind of wishy-washy language is if you have ambiguous language in your code, it's kind of hard to define. This, it's black and white. If you had those gray areas, it might lead someone to think that other parts of the code is up for up for interpretation. But like Councilor Dale said, it doesn't want to change anything.
It's
but
more
I just-
like
I like things clearly defined.
I guess it isn't really, but it's something like putting a statement in your code that says the city cares about these things, and so if someone complains, then we can say, see, our code addresses this, but it doesn't require you, but it sure encourages you to take action.
Encourages you to be a good neighbor.
Exactly.
Okay.
It's kind of like purpose statements and codes are nice, but then you have to have the actual standards. And our standard is clear for new development.
Mhm.
It's difficult to make it retrofit to all existing situations.
Mr. Mayor, since this is kind of a new issue to me, and I don't think we're in a position tonight to rewrite the ordinance, I would suggest we leave the wording as it's proposed tonight, and that we move on to the other items. And if we feel that we need to do something strong, we'll put that on one of our work session deals and work on it. But we're not going to solve it tonight, I don't think.
Yeah, because I worry about if we do put in something with more teeth, what are we unnecessarily creating elsewhere in the city where there's not a problem, because other people are being neighborly and helping each other out with that. So
this is one of those theoretical, or in a way a theoretical thing that we're looking for a hardcore solution, and I don't know what it would be tonight. So without more discussion, and so
It'd be a separate ordinance.
I'm okay with that.
Okay.
Everybody else okay with moving on? Okay.
All right. So moving on to page 30 of your packet.
I don't have a 30. Oh, sorry.
So we also, the Planning Commission did not recommend these changes for the same type of reasons, which I'll discuss here. Except they did, on page 31, they did recommend leaving that new figure in for clarifying that definition of a sign copy area. But again, the city's received complaints about businesses leaving and then leaving their signs up and not taking them down. And so what is proposed here, and one note on page 30, under abandoned sign B and then small letter A, the sentence that starts with restoration or not started within 90 days of the date the sign was damaged or not diligently pursued once started, that's highlighted, and it shouldn't be. That's existing in our code today. So we have some existing language in our code about if someone runs into their sign and doesn't repair it, then it says that that's not allowed and they need to fix it. And then the rest of the language is basically goes into what a definition of abandoned sign of something that goes out of business. And then on two pages up, it says that that's the definition, and then if you have a sign that meets that definition and has been abandoned for 30 days or more, the sign copy area should be removed. And I wanted to clarify that the sign copy area is not, that doesn't include like the poles and the sign brackets and everything. That could stay. Again, there are communities out there that make you take the whole thing down. That's probably pretty expensive. So, but the planning commission did not recommend it because this would be a difficult thing to enforce in many instances. Take considerable staff time. A good example would be the Shell station. That sign is probably gonna, unless the city has some sort of rules that they need to take it down, that's gonna stay there until there's another gas station. Because after 30 days it would be abandoned, and
Okay.
there would be a rule that says they need to take it down.
My question, I guess my question is the root of why we need this change. Has this been an ongoing problem, or is this stemming from one particular sign that was
I think it's
unsightly?
stemming from one particular sign.
So should we
Well-
maybe just address what kind of signs we can put in rather than having to enforce taking them down if the business isn't there?
Well, I think one sign kind of brought it to a head to this body and to the Urban Renewal Agency, but it's not just one sign. There's been multiple signs in town that business has been out of business for 3 years or more, and the building hasn't been reused necessarily. Although I think in one case I'm thinking it had, but they left this particular signing because it was integral to the awning. And that in the one case that brought this to a head is we had just spent a couple $1 million fixing up a neighborhood, and we had signs that were abandoned and weren't complementary to what we were trying to accomplish. My concern with not having language in our ordinance is if you do go to enforce something, you can't enforce what isn't there. And the Shell station eventually will become another gas station, or it will change use of some sort. But if they don't take their signs down after an appropriate period of time, you at least have a means to go in and have the sign
And we envision
removed.
this to, if it is left in, to be selectively complaint-driven type enforcement. So if there is a sign that seems to be easy enough to take down,
Or cover.
we can get a hold of, or cover, get a hold of the business owner. We have something that the code enforcement officer can say, here, see, it's in our code.
But there are several things in our ordinance realistically are complaint-driven enforcement. I mean, not every letter of the law is enforced every day. But when enough people say, they've been gone a year, blah, 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 at least you have a way of enforcing it if it's here. If you don't have it here, you can't. Other than encourage them to hide the trash can, you can't do anything about it.
Well, I like the idea of addressing the abandoned sign piece, because as we had with the C&J, I'll just say it, building. Well, it's
You're right.
out there, that it was not a well-done sign, and then it was up there for a while until it got repainted or whatever. Those kinds of things, they detract. Shell may be empty for 90 days if no one's attending the property to maintain it. It starts to become an unattractive area. So I mean, I like the idea that we have language that those that they come down. I know out at the Fred Meyer shopping center there, when a business leaves, they're required to take the sign off the building within, I don't know, a certain amount of days. It's part of the agreement of being in that complex. So, I don't know if that's sways any of that at all, or provides any.
We can't enforce it if it isn't there.
Right.
That's a good point. I don't have a problem with the language. I was just thinking if it was one thing, and Angie did mention it was going to be hard to enforce, but Councilor Ernst makes a good point that not everything is enforced to the letter at all times, so I'm fine with the language.
I had a question, Angie, on wording for the B abandoned sign.
Yeah, we need
Said, yeah, in abandoned is a sign.
it should read, an abandoned sign has one or more of the following characteristics. And then also, on page 32, well, I don't know if you like the way that reads, but I would propose removing, shall remove B deemed abandoned and it should be a sign that has been abandoned for 30 days or more shall have the sign copy area removed by the property owner prior.
I want to make one comment really fast, which is, we've been talking about, and maybe just in the vernacular, about the way in which we don't enforce these in the same way, and I think that isn't what we strive for. We actually strive to enforce them in the exact same way. What we get is notice of them in different ways.
True.
So it's the notice piece, because we don't always notice, and we don't always send people to go around, but once we are given notice of something, we enforce it. We try to enforce it in the exact same way every time. It's trying to be a level playing field for enforcement's sake.
Thank you.
Thank you for that clarification.
Yes.
Greg, remind me, when we moved out of, when our development department moved out across the street, weren't we faced with a dilemma there that the building was owned by someone other than the city? We had a City of Canby sign on it, and we had a dilemma that we wanted it taken down, but we couldn't because we didn't own the building. And so there, eventually it did come down, but we as the city who had left that building were without any recourse to compel that sign to come down. So this would address that. The other
Or
thing,
even to give us access to go cover it up or take it down ourselves.
the other thing that on the C&J thing that I thought was interesting is that people for whom their view of government is one of very limited powers were not pleased that this was beyond this reach of the city, that for a number of people for whom the role of government should be limited in their belief, they thought this would be a reasonable thing, that it was just, as Rich said, it was just silly that the city would spend $3 million improving a street, and we had no ability to touch a ugly sign that could have stayed up there forever. So this may not be perfect, it may not work, we may need to tweak it, but I think it gets us in a better place than where we are right now, which is the absence of any sort of policy.
I would agree. I think that, was it 32, the under 16.42, the abandoned site piece, I think it's a nice addition.
Okay.
So I think it gives us a little bit more oomph to go after some of those things.
Any other discussions about that? If not, we move on to page 63. This is regarding, if you look on, oh, it's highlighted on, under F, decision process, number 4. There was some question from council, I wasn't here, but I heard that there was some question about having the, in the case of Fred Meyer, having their attorney help prepare the final findings. And as it reads now, it says that prevailing attorney shall prepare. We're proposing, and change it to may assist in the preparation of, but it does say that in our code now. And it's, I think it, for one, it does help have an attorney draft those and let the applicant pay for that attorney. That's how I see it, so. But I didn't know that there was some discussion about that, so we just wanted to point out that we're gonna change it to, if council agrees, change it to may assist in the preparation of.
I think part of the reasoning behind it being shall was, you might have an opponent and a proponent, and whomever wins might have to fight it out on appeal. And so the idea was, make their attorney, who's going to be the one really fighting it out on appeal, prepare what they want to prepare so they don't, start complaining about how it was prepared by staff when they have to go argue it on appeal. So that was the idea. And I think this at least gives a little leeway so that people have to work together.
But don't you open yourself or the city up to more involvement? Because if, for instance, you were going to help or develop the findings, and the proponent comes to give advice, doesn't then the opponent get to come in and counsel too? So don't we continue the legal fees, if you will, to run prior to the appeal? I'm not making myself clear here.
No, I understand exactly what you're saying. I think there's a yin and yang on both ends, because you can surrender the process to the proponents and opponents and hope that they duke it out in the way that they see fit. Or you can have me involved, but then I still have to
Duke it
be
out
in the
with
middle
two
of them duking it out.
That's right.
And so, yeah, it's not a perfect deal when there's an adversarial system, but I think what the department was trying to do is respond in a way that it sounded like the environment here was of the mind that there should be more involvement than less in terms of concern.
So if we had adopt this and use you, for example, to draw up the findings, but the other two parties are going to be in consultation and involved, is the city able to recover our costs of developing these findings?
No, not because this would become the due process of all the different types of hearings. There's 4 of them. I believe it would be, on our dime, basically.
And is that what we want to do? Or should they pay for to prove their case, and particularly in case of appeal?
Well, as the counselor that was causing the fuss, as the environment.
I didn't want to point fingers.
Yeah, it's the fat guy sitting over in this chair. My concern at the time was that, as a council, we were being asked to accept language that our staff did not prepare and our attorney had not signed off on. Mm-hmm. And I got some education that night in terms of understanding that help me here, Rich, we don't necessarily have a dog in that fight. We were just accepting the findings.
Yeah, generally speaking, that's true.
And it states here, and for the second half of it, staff shall review and if necessary revise.
Right.
So, with that being said, does that not fall to Joe, to city attorney to
Should we add
review?
language that says staff and city attorney?
And I'll tell you, I have to be a part of that process anyway. There's a lot of shalls for the respondent city in terms of when it goes up to LUBA. So it isn't like I'm not involved. And in that case, I believe I had said I didn't look over it with a fine-tooth comb with the idea of correcting it because I wasn't going to.
Right.
Yeah.
Well, my whole concern for bringing this up was I'm just concerned on, it doesn't come up very often, but we could get a big one someday. A really big development someplace, and that's very contentious, bigger than a gas station. And I can just see our costs going through the roof, and we have no way to recover that cost.
I think that could be true.
Yeah.
Yeah.
So leaving it as shall would alleviate that? Is that what you're-
Yeah, I'm actually with Rich. I would prefer not to have ambiguity. I'd rather be unhappy with certainty, but know that
I'm going to write that one
I
down.
can my attorney can deal with that, right?
True.
It's the ambiguity that's tough to deal with.
Ambiguity leaves room for fight.
That's right.
Okay.
I think, city attorney can confirm this or not, but it's pretty common in a civil case for the prevailing attorney to write the order.
Correct.
Is it not?
Yeah.
And so I think what you pointed out earlier, the reason being, then we're not a third party, which both attorneys, prevailing and losing attorney, can come after us and go after the prevailing attorney. And so it kind of lets us out, except as a reviewer of the findings.
Correct.
So,
Well, it was 5 or more years ago, when I was on the County Planning Commission, and we were zoning the Cruise Way area for the first developments of Cruise Way outside of Lake Oswego, which was in the county at that time. And I bet we had 6 meetings just to come up with a process, you know, because there were so many attorneys involved, and even though the Planning Commission decided, we're going to do this, whatever that was, then we had 4 more meetings with the objections, and because we were writing, our staff was writing the findings. And it was just a nightmare. I mean, it went on for months and months. And that's just my concern, that we get into the same trap.
Great. Councilor Parker, do you have something? No?
So what's our feeling here for
I'm okay with shall.
I think we should
leaving it as shall versus may?
I would prefer to
So
leave
leave
it.
it as
Shall.
no change.
Right.
No
Yes.
change.
And then that would also be the same on page, the very, 2 pages, 65.
Correct.
That should be reflected across all the different types of
Yes.
hearings, yeah.
Okay. That's all of the discussion items that I wanted to bring up, and if you have any questions about anything else, yeah.
The only question I have, Mr. Mayor, is, and my papers I have thoroughly scrambled now because I don't have it in a three-ring binder. I don't recall seeing a resolution drawn up for us to adopt this.
There is an ordinance.
It's an ordinance?
We have findings, page 9 and 10, and then the ordinance.
Does anybody,
Okay, well,
Questions
like I
or-
say, my papers are so out of order now. that-
okay, so,
Yeah, I have a copy of that.
did you have some questions, Rich?
Okay, so resolution 1369 is implementing what we've just talked about?
Or ordinance 1369.
Or ordinance 1369?
Yeah. Okay, so there is no findings during the hearing. That's where I got it now. Figured it out.
Okay.
Thank you, I'm sorry.
No, that's okay. That's why we,
Hard day
that's why we
today.
have these presentations. Yeah, we'll move into questions from up here on the staff at this point.
On 16.89.090 modifications,
What page are you?
that would be page 66 of our packet. I'd like to hear some more about the rationale here. Overall, it reads like the Planning Commission is delegating its authority on Type 2 decisions to the planning director.
Yeah, the changes that we're proposing are under the intermediate modification. That's a change that was made not that many years ago, but before I arrived here. There was a desire to facilitate smaller type changes so that they could get through easier and quicker. And so in the language that we currently have in the code that was placed in there, they did accomplish that, but they did it in a way that actually does not comply with state statute. And that became very obvious when we did the Shimadzu manufacturing addition. They had a very good land use attorney involved and immediately pointed out, which I already knew from working with it, that we were taking advantage of this modification section to deal with that particular development, and they voluntarily decided to provide notice before the application, a decision was made on the application, because they knew state statute required that. And so what this is really doing is amending our process so that it actually complies with state statute, which means we're making it very clear that an intermediate modification is a Type 2 application, and Type 2 applications are administratively approved. They have an appeal process that goes to the Planning Commission, but that they're administratively approved and that you give notice before a decision is made and not after the decision is made. And that's what this is saying right now, is that you make your decision under a new business item if you want to at the Planning Commission meeting to keep them involved, which is confusing in itself because it's really supposed to be an administrative decision. And so there's been this, in the past, everything went to the Planning Commission. Well, if you're going to have a type 2 process, then it really is administrative, and it shouldn't go there to the Planning Commission unless it's appealed. And so that's what this is attempting to do, is comply with state statute, make it truly administratively, and give notice before you make a decision, which makes logical sense.
What, can you give an example of a type 2?
In this particular case, this one's talking about modifications, which means there's already a building on the property,
Okay.
and you're making an addition of some sort, and the addition would not significantly change the circulation pattern or harm the percentage of required landscaping, but yet it's, you know, it could be a significant addition, but if it doesn't really hurt the functioning of the site, then it's an intermediate, and you can do it in this administrative fashion. Actually, it worked like a charm with the Shimazu factory because it was a mirror image of what they already had. They had already accounted for that when they built the first part, and it was so easy for them to just add that big building out there, and we call it an intermediate modification. It worked like a charm. And it can most likely be for small developments that you're going to see something like this. If it significantly impacts functioning of the site or might make ordinance requirements a question, then you automatically treat it as if it's a brand-new application, and you go through a Type 3 process that goes through the Planning Commission.
So what we're looking at here at 16.89 is really existing buildings, not new building.
Right.
Not modifications to
Yeah.
a plan that's going
Yeah,
for a
an
new.
already approved plan that's been on record, so that you have a site
Approved plan
plan.
is in, you have a new project, say, for example, the gas station they're talking about. Just random example. They come through and they get their plan approved. They're not building it yet. Is this this is a modification to that kind of a plan, or are you talking about modification of existing buildings?
So the gas station got their plans approved by the planning commission. Say Cub comes in and it says, we need this tree moved over 5 feet so we can put our utility box here. Or these 3 bushes or something like that. We need to move those. That's technically modifying the plans that were before the commission. So, but it's not really significant. You're moving something slightly. So it's considered an administrative decision that doesn't need to go back towards the planning commission, but you do give notice.
So another example would be if someone the city owned 6 acres out in the industrial park and developed a plan that essentially built on 2 of the acres with appropriate parking and landscape, but with a long-term idea of eventually building out the rest of the 6 acres over time. When they came back in to add on to that building, maybe even 2 or 3 different times, it would be handled under this type 2.
It could be. Yes.
Could be.
Yes.
He says cautiously.
I have quite a bit of discretion actually within the code to make the determination of whether it's a minor, intermediate, or a major modification. But the key is that it's a modification to a previously approved land use application.
Yeah.
That means we already approved the site and design review for this property, and we have an approved site plan. Now you're evaluating what they want to do in light of that approval, and is it going to be a significant change? If so, go back and do a whole new application. If it's intermediate, hey, that's something I could actually approve. Or if there's minor ones that, like she was describing, hey, you want to move a transformer on the site, hey, we don't have to go back to the planning commission to get the approval to do that.
Okay, good.
I actually encouraged Brian to make administrative decisions instead of taking 3 months or whatever to go back to the planning commission if it is something that they can do administratively, and it's just a matter of moving something on the site. But, I mean, Brian gave me examples of where some small thing had to be changed, and if he can't do that administrative decision, it goes back to the planning commission, and I think it's, makes you look not business-friendly in the community, and especially places like Shimadzu. They were, I mean, that's not our problem that they were in a hurry, but it's still, I think, is more business-friendly if we can make administrative decisions and they're done correctly. It's not like he's eyes only, the only eyes on it.
Yeah.
And so I think it's a plus to be able to do that.
Okay.
Yeah, I guess for me, I was just trying to figure out where that bar is. And I don't want to slow things down. I don't want minor things that take 3 months or more fees, but I do want a good check and balance. I don't want the planning commission to delegate away authority that properly belongs in that branch of our government.
That's right, and that's what I've told Brian. I said, if it's the correct thing to do, fine, but if it's administrative, let's make it administrative, let's make a decision. At the lowest level, we can make a decision. That's a correct decision.
And what's the part, you said that state statute requires this behavior?
A notice.
Notice.
The notice part of the
Yeah.
behavior.
Then
Before, not
everybody gets
after.
notice,
Yeah.
neighbors.
Gotcha.
Yeah.
Not that the planning commission or the planning director makes the decision. It's the notice portion.
Yeah, the real crux of what this change is doing is the previous process was to the planning commission, but they called it a type 2, which made it confusing. Because normally type 2 processes are administrative. And so it took it to the planning commission and you placed it on their agenda as a new business item, and you could get it there within a week because there's no notification to anybody. You just stick it on the agenda, you make a decision, and then after it's done, you send notice out to
That we made a decision.
surrounding property owners that you made this decision. And what I found through practice is that invites appeals. And then if you get an appeal, your process just was tripled in time limit when you were trying to shorten it. Because somebody says, well, I didn't know about this. So you should always notify before you make the decision, because that's going to lessen the potential of an appeal, and then your process really will be shorter. And so what I'm trying to do is continuing that idea that we're making it shorter, and the only way to do it logically in accordance with a type 2 process is not to take it to the planning commission at all. And so it's kind of complicated.
No, I get it. I mean, I'm uneasy because I see a delegation of power from one branch to another. If it was national, it'd be from legislative to an executive branch, and that makes me uncomfortable. But I don't want to be a nuisance either. And so that's why I'm trying to figure out where that, what is the trigger point? And so when I hear things like a Shimadzu expansion would have qualified
That's an intermediate? That's,
as an administrative decision,
It was.
my
That
goodness.
did not go to the planning commission.
that seems more than intermediate to me.
No, but
in my
what Brian said
world.
was, that decision was made back when they first built the first section. They had planned on that expansion.
Okay.
And that was part of the approved.
And that was the example that Councilor Ayers had indicated on the city property, is that because it had previously been master planned, it was
Okay,
all set up.
So Shimadzu did have the full expansion master plan.
Yeah.
It'd be like American Steel, for example, if
Gotcha.
they thought at some point, you know, and sited their building so that they could expand the warehouse or the
Right.
train station inside or whatever, you know, that would be, that's part of the natural evolution of that facility, as opposed to a whole new use on the land, or
Right.
different use.
If they had not done that previous planning, then they probably would have had to have new driveways out to the street and
Right.
typically
Access
change
points.
type
Okay.
of access points, and
Yeah.
then, hey, that's major site planning type stuff.
Okay.
That we would have had to go to the planning commission. I would have said new application.
So in the case of Shimadzu, from the get-go, Planning Commission had their shot at it. They had blessed the master
right.
plan. So in the course of time and prosperity, when it was time, great. were already approved. Okay, I see Bev shaking her head, yes, it was good. Okay.
You're tracking well then.
I am checking. Bev shaking her head.
Okay. Does that shore that up for you?
That's okay.
Any other questions or comments? Okay.
Need to close the public hearing, I think.
Oh,
unless
yeah, we need to close the
Yeah.
hearing for them.
Or allow for
I need
any,
to open it first.
any comments, yeah.
Do you have any other questions of
Yeah, he
staff?
opened it.
From
Yeah,
there?
he read the rules.
You opened it when you read that.
Yeah, on page 14.
Yes, if there were people-
16.5.20, a lot of yellow and a lot of crossing out about written interpretations.
I'm sorry.
Page 14.
Then what page?
14 of the packet.
Yeah, how this reads is poorly written. What staff and the planning commission found. Basically, it says now, it said that after every interpretation, the planning commission, the planning director shall issue it in writing and mail it to the person who requested the interpretation. Any other person that requested a copy. This just never happens. I mean, interpretations really happen over the counter. And then there are everyday stuff such as, do you measure the pole height from where you stick it in the ground or the actual, if you have a pole and stick it in the ground, do you measure the height of the pole
Plus
before
the
you
6
put it in the
feet,
ground
yeah.
or after, or little things like that, that are everyday over-the-counter type questions.
And this eliminates the need for written notification of those things?
Yeah.
Gotcha.
But if there's something more complicated, such as, I think one instance was the FCC requires me to have a 16-foot pole, but our code said 15.
Mhm.
Well, you know, in this case, that the code doesn't really, that doesn't make sense, what we have in our code. So we'll make an interpretation that the intent of the code was to allow a pole that complies with FCC regulations. And we probably should write that down because it was kind of a complicated decision that took more than 5 minutes.
Okay.
Something like that.
Okay, gotcha. Page 23, 162170. Just wanted to hear your thoughts. I noticed throughout that it looks like we've lowered the percentages in order to qualify on points.
We found their use, but they are very hard to obtain.
They're just practically speaking, they're very
just-
hard.
Yeah, they're just, we've had to creatively interpret them as they are now and cross things out and say certain items aren't applicable, and I mean, that's what we did for Fred, or you didn't say the Fred Meyer one, but just so we could re-tally the points and just, because we don't, the point is to not prevent a development because they can't pass these tables, and
Right.
if you strictly interpret them now, I mean, no one would pass.
And that's how I read it, as being a little more development friendly.
Yeah.
Okay. Just wanted to hear a little history on that. Let's see. Thank you for going to lumens. That was good. Almost there. Okay, we answered that one. It's a minor thing. You mentioned on page 51, and there's another spot as well, you removed the selection of species. It looks like you removed the standards that we would use. So, having been in a tree species dispute lately in our neighborhood, I was curious about who decides?
I'm sorry, on page 51 of the packet?
Yeah, down at the bottom of the table, lower left hand.
It says that. I've looked for a list, it's drought tolerant species per Metro's list. I have
No such thing.
no idea really what that's talking about, and I've found that in Canby, you avoid the word Metro.
Yeah, right. Well, I'm not disagreeing with crossing out. Any chance you get to cross out Metro, it's okay.
There's many lists other than from Metro. I mean,
Right.
that you can, I use, I think it's kind of a preference, but there's lots of lists of drought tolerant. I mean, you can Google any species and get like an OSU rundown of how much water this plant requires.
Oh, yeah.
So I think there's multiple sources.
Our city forester has quite a good list too, of
Yeah,
approved
too,
species.
yeah.
And so it was just curious to me to remove the standard out of the code. Did that leave us in an ambiguous place to
We are,
get in a fight?
I think we are somewhat ambiguous now, and I think it's good to, I think there could be multiple opinions of what's drought tolerant and what isn't.
Right. So in the end, the decision lies with planning?
Yeah,
With consultation with our arborist, since we have one.
Yeah,
We
a
always
great one.
do.
Okay. And my last question, Mr. Mayor, was page 65. This is probably actually more for Joe. Section F, page 65, City Council Proceedings.
Yeah.
And point number 2, it says the city council may question those individuals that were a party to the public hearing. And if the commission's record appears to be lacking sufficient information to allow for a decision. And then the next sentence is the council shall hear arguments based solely on the record
Yeah.
of the
Kinda
commission.
does.
It's, you want us to
Well-
base on the record, but we can call in a witness to fill in.
You can have the power to hear more information. There's a difference between information and argument.
Okay.
If I make a closing argument, for instance, I might have 3 main points. Well, there might be more information that you find pertinent that either cuts against or helps those arguments, but to open up whole new arguments that were never made down below is usually when people try to streamline. So if you've never made an argument before, it's within this ordinance here to say, look, you can't make new arguments now. Now's not the time for new arguments. Maybe new information or new facts that might bolster those arguments, but don't
Okay.
make new arguments.
So clarification's great. Don't bring us new arguments.
That's right,
Okay.
if that helps.
That does help. Thank you, Mr. Mayor. Thank you for your patience.
Yeah, not a problem. I guess so with that, we'll open up the hearing for testimony from, so any proponents to said information this evening? Seeing none, any opponents? Seeing none, we will close the public testimony. Any other questions or discussion items here for this body here? Okay. I guess that takes care of that public hearing piece. So moving into resolutions and ordinances, number 8 on our agenda this evening.
This is the one for this, right?
Yes, this is tonight's, the ordinance 1369. Sorry, Kim, I'm taking,
It's
go
okay,
for
I
it.
was zoning. Before you use ordinance 1369, amending Title 16 of the Canby Municipal Code.
Okay.
And Mr. Mayor, in consultation with our city recorder, I'd like to move that we direct staff to make the changes to the language that we've identified tonight.